Hello, everybody. The following video is the bankruptcy attorney I interviewed as promised, because unfortunately, we are coming to a point where people are reaching out and are realizing they're not going to make their way through. So there are all kinds of questions, and I tried to ask as many as I could. So a couple of things you need to know about this video is that it's the longest video I've ever done, but I do encourage you to watch through it all if you are an individual who is concerned about the possibility of going bankrupt. And the other thing I want to make sure to let you know is that my hair looks crazy, but I don't want that to divert focus from what the message of the video is. I did not want to reschedule an interview for a bad hair day. So just keep that in mind to try and ignore it the best that you can. But it was an important video to do and make sure that I got out to you as soon as possible. So hopefully the information is good for you. Miss Barnhart's contact information will be included at the end of the video along with my own. And of course, if you have any additional questions, please reach out. Thanks so much. Welcome back, everybody. Today, as promised, I have Kelly Barnhart here to talk about small business bankruptcy. Unfortunately, with COVID-19, while the relief program certainly kept businesses afloat for a short period of time, I know that I don't know about you, Kelly, but I am already starting to receive calls from people who simply aren't going to make it. And it's nothing that they did wrong. Maybe they were in trouble to begin with, or maybe their industry just simply does not allow for them to get beyond the social distancing rules. But the bottom line is they're not going to make it, and they can't just drop and go, right?
That's correct. I think that, unfortunately, if a business has determined that as a result of COVID-19, whether directly or indirectly, they simply cannot go on, then they have determined that they're overwhelmed with debt, and then they have to start considering their options. What are they going to do? They know they're going to need to shut down the company, and then they have to start considering whether bankruptcy would be the option to shut down in a clean method rather than dealing with multiple creditors calling them constantly.
Sure. So, of course, the big question everybody had when all of these relief loans started coming out, as all of you are aware of, were, well, what if our business doesn't survive? Do we still have to pay the PPP back? Do we still have to pay the EIDL back? And I think the answer is yes, unless they go through a bankruptcy.
That's absolutely correct.
Okay.
So outside of a bankruptcy, they're still going to be on the hook. And so that means that there's going to be collection efforts. They're going to have to deal with the SBA in some fashion routinely. And I think that the cleanest way of dealing with it, if they just want to be behind them, whether it's EIDL or the PPP money, is to file a bankruptcy so that the SBA gets the notice the company is shut down and it's no longer operating, so that once it gets the notice, it can write those debts off the books.
Okay, so everybody, that's really important. You don't just get to close the business and walk away. I know there's a lot of information out there that says that you aren't personally responsible for the PPP, and as long as you have under $200,000 of the EIDL, you're not a personal guarantor. But unless you go bankrupt, you will be responsible for paying those debts off. So I think that's like number one takeaway here, is that you don't get to just walk away and close your business. And of course, now the next question everybody asks me when they're talking about bankruptcy, and I am not a bankruptcy expert, everybody, that's why Kelly is here, is how does it affect the owner? And theoretically, if the business goes bankrupt, it shouldn't affect the owner unless they personally guaranteed those debts.
That's right. And so that's one of the questions I get routinely when somebody first comes to see me during their meetings is, how is this going to impact me individually? Am I now going to be on the hook, even if I didn't personally guarantee it, because I own the business and the business is shutting down? And the answer is no. Unless you've personally guaranteed it, there should be no obligation for you personally to repay this creditor. If you've personally guaranteed it, then of course you're going to have to do your own due diligence as to your personal situation. But simply speaking from a strict business aspect, the owner of the business is not going to have to be responsible for that obligation if the company files a bankruptcy, closes down, et cetera.
Right. So they're probably okay when it comes to the PPP and the EIDLs. But if they have guaranteed any other debts and they go bankrupt, they might still have a problem with their personal credit, and they're going to have to consider whether they individually need to go bankrupt.
Absolutely, because what happens is if a creditor knows that a company has closed and or they get a notice of bankruptcy filing, they're immediately going to pull the file to see if they have any personal personal guarantees on file. And if they do, they're going to come hard after those individuals.
Sure.
And so the only way you're going to deal with that is either paying it off. That's a luxury most people don't have. Reaching a settlement with the creditor. But if there's multiple, that might be impossible. Or third, considering their bankruptcy options. And you did bring up something important to discuss, which is credit scores.
Mm-hmm.
How does this impact their credit scores? If, for instance, let's say just the business files. Well, if just the business files, that should have no negative impact on the individual owner's credit score because it's not their personal or consumer debt. If, on the other hand, somehow it's related to a guarantee and it falls within the reporting requirements for credit reporting, then it will be reported.
On them individually.
On them individually.
And as long as they're keeping up the payments and anything, no harm, no foul. But
Right.
the minute they stop paying for that, then it starts to hit their individual credit.
Absolutely. And it usually has a
Right.
ripple effect.
Right. Well, and and especially now, a lot of people are using a lot of debt to try to stay afloat that they personally guaranteed for. So this isn't on the question list. But I think before we move on, I would like you, and I should have asked this question first. Sorry, everybody. I always forget this part because I just want to jump into the meat. But tell us a little bit about yourself and your firm and what it is that you specialize in. Because we're talking about small business bankruptcy, which I've told everybody you specialize in. But then when it comes to the individual, do they stay with you? Do they go outside of your firm? What happens there?
That's a great question. And so usually what happens when somebody calls to make an appointment and they're a business owner, I have two different forms, one that's a personal form and one that's a business form. So when they meet, usually I will do two consultations. I will discuss their personal situation and the business situation. If it appears there's conflicts, meaning for some reason either one owes the other money or has some kind of claim against one another, then I'm going to be conflicted out. And so I can only represent one of the two,
Sure.
but then they get to make that decision. But once they make that decision, meaning they decide whether they want me to represent them personally or the business, they can't switch midstream.
Right. Okay.
And so going to my background, I've been doing this since 2004. I specialize in financial workouts, tax matters, bankruptcy, anything that's financially related to a business or a business owner, I'm going to do. I do some consumer cases, but I would say consistently, my business is primarily small businesses and small business owners.
And now you told me you've been at this for 16 years?
That's right.
She's been at this for 16 years, and y'all, she chose to do bankruptcy in law school. I'm just saying.
That is rare. Most people who are in law school or in any school, they don't know what they're going to want to do. I was fortunate, unfortunate, depending on how you look at it.
Well, it's rare and maybe a special kind of crazy. I can dig that because I think I have my own special kind of crazy going on. But I just wanted to work that in, that not only has she been doing this for 16 years, but it's the only thing she wanted to do when she was in law school.
Yes.
So I would say you're not going to find a bigger expert in this field than this person right here. So, all right, now back to our question. Now, what is the process of bankruptcy? Like, what's step one, step two? How does that work?
Okay, step one would be to make an appointment with somebody who's knowledgeable in bankruptcy.
Right. Well, and in this case, business bankruptcy.
Correct.
Very important.
Which, especially in our location, but mostly everywhere, that's going to be a small percentage of the people who actually do bankruptcy.
And I want to be very clear here. These are two different things. Business bankruptcy is different from consumer bankruptcy. So.
That's right. And so first, you're going to need to find an attorney. Second, you're going to call them, make the appointment. The attorney should send you a packet of paper that you need to fill out before the appointment. And so that first packet of paper is going to be very important because it's going to ask for a number of documents. It's going to ask for information, all of which is relevant to the filing of the bankruptcy.
And how much time should an individual put aside to deal with that packet of paper?
That's a good question. I would say at least 2 hours.
Okay.
So it's not something that if the appointment's on Thursday, Wednesday night, they go, oh, let me pull that out real quick and put it together. Because unfortunately, it can be overwhelming at that point.
Mm-hmm.
And so you would collect that paperwork, you would have the meeting. At that point, the attorney, if it's me, whoever it may be, is going to advise that person of what they think the best options are going to be. Okay. Now, let's assume it's a business who is going to try to restructure its debts rather than close the business.
And so by restructure, you mean not go out of business.
Correct.
Just work with the courts to make sure that the money flows
That's right.
Okay.
And so when I say restructure, it literally means a restructure of the existing debt. The company may not have to pay it back in full. They
Okay.
may only have to pay back a portion. That will be dependent on the facts of each case. But it's a restructure of the debt, so it becomes a new contract. So if you had 10 contracts with creditors in the bankruptcy, the ultimate goal is to have a confirmed plan. That plan becomes your new contract with all the creditors.
Okay.
So you've met with the attorney, you filled out the paperwork, you have finalized your bankruptcy documents, let's assume, your draft. Okay. And what do I mean by that is when you file a bankruptcy for a business or for anybody, really, there are certain documents you have to file with the bankruptcy court. And the attorney has to review those with you first. And then in a meeting, they will go over it with you and sign it to make sure that under penalty of perjury, it's accurate.
Okay.
When you've done that, you're now officially in a bankruptcy. Once you're in a bankruptcy, then you have a number of different hurdles you have to get over. So the first is going to be you have a meeting of creditors.
Okay.
It's exactly what it sounds like, meeting of your creditors where they're allowed to ask questions. But the Office of the U.S. Trustee oversees all bankruptcies for businesses, Chapter 11s, and they will conduct that meeting.
Okay. And what are the creditors doing? Are they trying to convince them that a bankruptcy isn't necessary? Are they just trying to get their little piece of whatever might be going? Like, what's happening there?
So there's a number of things. One, they might want to understand, why did this company file a bankruptcy?
Okay.
Two, they're going to try to realize what are the actual assets that can result in payment. Now, normally with the business, it's going to be their accounts receivable, whatever the case may be from whatever type of business. So they're going to see, is it realistic that the debt is going to be paid back? And if so, at what percentage? Because creditors know normally in a bankruptcy, they're not getting 100%. Sometimes they do, but it's rare.
Mm-hmm.
The third thing is they're going to be looking through their files to see if there's anything amiss, meaning, did this company just give us a financial statement saying that they made $10 billion, but now in bankruptcy, they said they're only making $10 million? So the creditors are also going to be looking at that. But normally, at least in this area, it's very cohesive, meaning the creditors and the debtor's attorney usually work together because we're all trying to get to the same result, this company to succeed. As weird as it sounds, bankruptcy is the opportunity to be able to pay back your creditors. So your creditors are going to be invested in the outcome too.
Okay. All right. Now, I know with an individual bankruptcy, there are some qualifying factors about whether or not you actually can declare bankruptcy. There's some calculations that need to be done. I mean, because you just can't go declare bankruptcy without proving the math, right? Is that also the same case with small business bankruptcy?
Absolutely. And first and foremost, I'd like to identify the companies who cannot file a bankruptcy.
Okay, great.
So there's actually a list of companies that cannot file. So you've got state mandated banks. You have savings banks, credit unions, insured banks, foreign insurance companies. All of those cannot file what's called Chapter 7s, the liquidation, the shutdown of businesses. They cannot do that as a Chapter 7. Family trust cannot file regardless. So if you've set up a family trust to own real estate, but it's not a business trust, and now that property goes into foreclosure, it cannot file a bankruptcy.
Oh, so be careful about how
you set up
your property.
Correct. So that's really important. Railroads and uninsured state banks that may be able to file under Chapter 7, or may not be able to file in Chapter 7, may file for Chapter 11. So it's kind of weird. If a railroad was to close down, let's say Norfolk Southern, it's not, I'm just saying, use that as an example. It could not file a Chapter 7 to shut down. It could file a reorganization.
Okay.
Stockbrokers and commodity brokers may not.
Okay.
So getting back to the factors of dollar amounts, though, because that's a really good question.
Mm-hmm.
So there was a modification of existing bankruptcy law not too long ago where they created a new small business debtor, Chapter 11. And it's called Subchapter 5. A lot of people talk about Subchapter 5s, but unless you're in the know, that makes no sense.
Right.
Subchapter 5 is the new rules for small business debtors to try to streamline the process, which makes it shorter and less cost. It's not as expensive. So it's more cost friendly.
So it's the bankruptcy EZ form.
Correct. Yes. Yes, that's exactly what it would be like. And originally the debt limit was approximately $2.7 million. So that would help a lot of companies around here. But with the CARES Act, when Congress passed the PPP money and various different aspects of bankruptcy law was changed under the CARES Act, they actually increased the debt limit to over $7 million for small business debtors to qualify under that special, very streamlined process.
Okay.
So if you have $7 million or more than 7 million, you're going to be in the regular Chapter 11. But if you're under that number, then you're going to be able to do the streamlined Chapter 11 called Subchapter 5, which is a really big deal.
Okay, so in terms of bankruptcy options, then you have Chapter 7, which is basically company shuts down, and you better not be one of those businesses or trusts that you mentioned.
Right.
You've got Chapter 11, which is restructuring of debt. And as a subchapter of Chapter 11, you've got Subchapter 5.
Okay, yes.
Small businesses.
Yes, I know it's in my world, we all know it, but it's weird. So you have the regular Chapter 11, which any company could actually file. Then you have the normal small business debtor,
right?
That up until very recently we all knew we loved, but it wasn't as user friendly. And then, not related to COVID-19, they had passed this Subchapter 5, and it had just gone into effect. And then, unfortunately, the pandemic broke. And then when that happened, when they did the CARES Act, which is the congressional act where they, made a lot of changes, including PPP money and making that available, they actually looked at the debt limit and they said, we're going to increase it so that more businesses who are going to be negatively impacted, either directly or indirectly by COVID, should have the opportunity to take advantage of this. And so until March 2021, that's the current date, any business with 7.5 million approximately or lower may qualify to file under this subchapter.
Okay. Well, that's a big amount actually for my demographic.
Yes.
That's a big amount. So that covers a lot of small businesses.
Exactly. And I anticipate they're going to change that March date, and and the March date runs 1 year from the enactment. So I believe that's March 26, 2021. Mm-hmm. My expectation is that they're going to extend that, because when they first did it, they were anticipating, probably optimistically, that the impact of the pandemic would be shorter than what it ended up being.
They were very optimistic on that.
Yes.
I think it's going to be another 12 to 18 months before we start to see true recovery happening.
I think that's right.
Unfortunately. So, all right. So, of course, this is the burning question on everybody's mind. Just how much does a bankruptcy cost for a small business owner on average? And you can give a range too.
Okay. So for the individual owner, it's probably, so if they decide they need to personally file.
No, I'm talking about the business.
Okay. I can do both. But
yeah, absolutely.
So for a business, if it's restructuring, the court is automatically going to charge $1,770. That's just the court costs.
Okay.
Then the attorney is going to charge on an hourly rate. And it's going to be based on the complexities of the case, how many creditors, how antagonistic everything is in the case. But I would say the range safely is going to be anywhere between $7,500 and upwards of $40,000, depending again on the size of the company and what's involved. Of course, if you can qualify and it makes sense to be in the subchapter 5, you're going to streamline some of that to reduce those costs. But I think that that's a fair estimate. I would say it's probably going to be in the range of somewhere between $7,500 and $20,000. But I don't want anybody to say, well, you said this is the upper range.
Yeah.
Because it's hourly, and I can't predict how involved, unfortunately, the case is going to be.
On the range of hourly rates for lawyers too, ranges anywhere from $150 an hour clear up to $1,000 an hour.
Yes.
So
yes.
Yeah, absolutely. So do your due diligence and interview. Okay. Then how long does a bankruptcy take?
It's
okay. From beginning to end.
It depends on, again, how much is involved in the case and how, I would like to say reasonable the creditors are, but also the debtor, how reasonable the parties are in getting to the end result, which is a confirmed plan. Mm-hmm. But I would say in the subchapter 5, you have to have a plan filed within 90 days of the bankruptcy case. So you probably could get through an entire bankruptcy in less than 6 months, ideally.
Okay.
That's very streamlined. I'm known for trying to fast track my cases and get them moving, because I know that no one wants to stay in a bankruptcy indefinitely.
Sure.
And the sooner they're out, the more likely they are to make money and be able to pay their creditors. So a normal Chapter 11 beginning to end is probably anywhere between 12 and 14 months. And that's that is considered fast track.
Right.
So this new subchapter 5, allowing the plan to be filed within 90 days and then having this hearing and having it hopefully all wrapped up within 6 months is the shortest version of a bankruptcy that I'm aware of for businesses reorganizing.
Okay. Now, there's something else I want to mention because I run into this every now and then when I'm doing tax resolution. For example, we're in the, we're going to do an OIC for taxes that an individual owes because a bankruptcy does not abate that at all. You're going to be paying those taxes unless you come to me and we're going to do something called an offer in compromise where we negotiate a reduction of your liability, which, by the way, I can't do while you're in bankruptcy. The bankruptcy has to be discharged. So I very often advise people to come see me about an OIC first and then go to bankruptcy. Is that what you recommend, or do you recommend the opposite of that?
It depends on the facts of the case, but typically what I would like to see my clients do, especially the individuals, if we know that they're going to have tax debt on the other side of a bankruptcy, right? So if for whatever reason, either it's income taxes that aren't dischargeable because they're not within the time period, or for instance, their payroll taxes, which are never going to be dischargeable.
Well,
normally for the owner, the trust fund portion will not be dischargeable. What I recommend is that they actually negotiate that before they file so that I already have that built into their budget. I know if, for instance, if it's going to be a plan payment with the IRS, I want that in their budget because I need to show the trustee and the creditors what they can afford, what they can't afford. And if I have this great unknown, it's impossible to advise them or the creditors what's going to happen. So normally I would like to see them have engaged with the IRS prior to bankruptcy filing.
And so what we need to really establish here is that most businesses, the tax debt that can't be discharged is payroll taxes. If the business shuts down or goes bankrupt, the IRS doesn't care. What happens is the trust portion, which is basically the portion that was the employee's money, gets associated with your individual account. They get assessed to your individual account as civil penalties. So we actually need to do 2 OICs, one for the business and then one for you individually before either of those go bankrupt to make sure, because once you're in the middle of the bankruptcy, I can't do anything until the bankruptcy has been completed, discharged, signed off, whatever they do, but it's over. And I can't help you during that period of time.
No, and that also for businesses who are considering a Chapter 11, if they have tax issues, we'll say, in the Chapter 11, whenever you employ a professional such as you or such as me, the court has to approve that employment before the party can start working on behalf of the company. So if they have tax debt, I would recommend my clients employ you, get that approved. And then as we're negotiating the terms of the plan, something that business owners aren't aware of, all tax debt in a bankruptcy, unless you get them to agree otherwise, has to be paid in full in 5 years from the petition date, not from the plan date. And so it's going to be very important if you're involved, for instance, that we all know these are our deadlines and to try to figure it out and have it sorted so that when we have our plan that's proposed, we've either gotten the IRS to agree to something different, or B, we've made sure it is possible.
Right. Yeah, because sometimes the 5-year plan it's not realistic when you have a lot of debt. There's no way you're paying that every month. Yeah.
And it may be that you negotiate something where month 59, all of a sudden we have a balloon that the IRS is going to let us on the other side renegotiate again, but you need an accountant more than likely to handle that for the business.
Well, and specifically you need a CPA.
Correct.
Or an enrolled agent or an attorney, because those are the only 3 fiduciaries that can represent you to the IRS. So that's very, very important. All right. So I think we covered a lot of questions today. Is there anything I was missing?
I don't think so. I think that the one thing I would like to say to business owners, actually, if I was given the opportunity, is there is no real stigma to filing. I think a lot of people, pre the pandemic at least, thought that there was a negative stigma if they end up having to admit that they need a bankruptcy to restructure their debt.
Okay.
And I don't think realistically that there is that stigma except in your own head. And I don't say that cavalierly. I'm a business owner, so I know what it feels like. But I would like owners to know that bankruptcy is there as an option. It's usually a very friendly tool. Use it if you need it, and and don't believe that there's going to be this negative stigma with respect to the business being able to succeed if it files for a bankruptcy.
And I think that's a very good point to make. I mean, you don't want to use it as a tool for irresponsible spending and not managing your finances. But years and years and years ago, I went to a conference that I was invited to for entrepreneurs, and I was a military spouse. It was specifically designed for military spouses. And I met a lot of different entrepreneurs there. And let me tell you, the ones that I met that were successful had failed at businesses 2 or 3 times before they actually found the thing that worked for them. And it wasn't that they went into the business thinking, ooh, bankruptcy is what's going to get me out. Clearly, that's not what was happening. It wasn't happening for them. And they had to go bankrupt. And did they have to climb out of a mess? Sure, they did. But they eventually did. And they didn't give up. And they didn't let a stigma of, affect their ability to get to where they are today. So It's a great point. But again, be responsible.
Yes. Yes. Don't run up debt and then come see me and ask, can you file a bankruptcy? That's not what I was saying. What I'm saying is a lot of times businesses need to restructure their debt, not through any mismanagement or through their own fault. It is something that just happened to them. For instance, the pandemic.
Right.
It's outside of your control, but unless you consider all of your financial options, you may have no choice but to close down the business, whereas a bankruptcy may be an effective way to keep the dream alive as long as you're able to restructure the debt.
And those are things that you and I can help people decide as they move through the process.
Absolutely. I would say, please talk to a CPA, please talk to an attorney before making any major decisions about your business regardless.
Absolutely. All right, you guys, that's all we have today. Kelly, thank you so much for coming and doing this. I met her last week over a Zoom meeting and I was like, we've got to do this. So now, however, she has turned the tables on me a little bit and she came in with a whole list of questions for me. So we're going to cut this video off. But next week, you're going to see the next video that I do where she has turned the tables and is asking me the questions. So that should be fun, interesting, and we'll see you all next week. Thanks, everybody.
Thank you.